Welcome everybody to the Health Law and Ethics Network monthly seminar. My name's Paula O'Brien. I'm an Associate Professor at the Melbourne Law School and one of the directors of the Health Law and Ethics Network. So a warm welcome to everybody who's joining us today. I'd like to start by acknowledging the Wurundjeri people of the Kulin Nation on whose lands the Melbourne Law School stands. And I'd like to pay my respects to their elders past, present and emerging, and acknowledge that their lands were never ceded. Today, we are very lucky to be joined by three outstanding researchers who are going to be presenting on the topic of reproductive coercion, and they'll be talking about their findings from their study of the views of domestic violence support workers and lawyers in respect of reproductive coercion. We have Professor Heather Douglas from the Melbourne Law School. We have Dr. Laura Tarzia from the Melbourne Medical School, the Department of General Practice, and we have Dr. Nicola Sheeran from the School of Applied Psychology at Griffith University. So we are really pleased to have you along today, and thank you for speaking on this really important topic for us. So I'll hand over to, I think it's Nicola who's going to start for us.
I'd like to thank you on behalf of us as presenters for the invitation to present today. As mentioned, I'm Nicola, I'm from Griffith, so I'm in I would say much warmer place than where you are right now, but it's actually a lie because we're freezing. So cold snap in Brisbane. But we're going to be talking about a study that we have done that was around really trying to understand the legal context and how people are responding, or workers who are supporting women experiencing domestic violence were responding to reproductive coercion. So to kick us off, I'll just start by clarifying definition. And we'd think that this would be quite an easy thing to do, but actually it's still actually being contested as to how we actually go about defining reproductive coercion. We'll talk a little bit about why that's a problem in a moment, but a general definition that is accepted at the moment is around there being deliberate attempts basically to dictate a woman's reproductive choice and to interfere with reproductive autonomy. One of the recent changes that's actually come about through a lot of the work Laura has been doing, but certainly I also agree, is around expanding it from just reproductive coercion to reproductive coercion and abuse as a way of recognizing that there's a whole heap of tactics that perpetrators can use in enacting reproductive coercion. So it can include physical, psychological, and sexual tactics, and it occurs in a context of fear and or control in that interpersonal relationship. And we talk about 3 or 4 sort of broad categories in which we can classify some of these behaviours. So around trying to coerce somebody into a pregnancy, and that can be through sexual assault with the intent of causing pregnancy. It can also be through contraceptive sabotage, hiding, restricting access to contraception. The other general cluster is then around preventing somebody from becoming pregnant who may want to, through, again, lots of coercive tactics, violence and control, financial tactics and things like that. Then the other part is around when that person actually then is pregnant, it's pregnancy outcome control. So coercion towards abortion, forcing, threatening if they don't have an abortion, or coercion towards maintaining or continuing that pregnancy when the pregnant person does not want that to occur. So really helpfully, Laura, in a recent paper, put together this model. And so it really starts to show some of the complexities. So when we're talking about definitional debate, one of the issues is that many of the tactics that are used can overlap. And so, like I said, there can be sexual assault or rape that is then causes a pregnancy. So it intersects with sexual violence. It intersects at times with intimate partner violence. And obviously there's those two overlap themselves. And we also then have intersections with family violence, where we can see other members of the family who may be involved. We've had examples of people being held down, mothers-in-laws holding them. Hope that's not one of our findings that we're going to talk about later. But certainly there are other family members who become involved in the perpetration of the reproductive coercion. There's also a whole heap of factors that have been identified as contributing to reproductive coercion, and they can be around policies that prevent or impede And this is often referred to as structural reproductive coercion. So there's argument within the field as to whether we're talking about reproductive coercion abuse that occurs within intimate partner relationships versus the more structural level impediments that also then prohibit or impede a person's ability to have reproductive autonomy. But certainly here we can conceive of those as factors that would contribute to the perpetration of reproductive coercion. Whole heap of stuff around access to sexual education, religious views, patriarchal norms, gender inequality, and structural inequalities. And then, of course, there are protective factors that are the converse to that. The interesting thing that Laura's paper in this instance did was center this idea of intent. And again, this is another thing that even Heather, Laura, and I will debate, is about the importance of that. Certainly from a psychological perspective and from Laura's perspective, having intent at the center there, that this person intends to control reproductive autonomy, as opposed to it just be a pattern of coercive control or violence, may or may not end up having implications down the track for interventions with perpetrators. And so recently there's been a lot of debate about the role of intent, or the focus of intent in delineating or helping to clarify what might constitute reproductive coercion and abuse from other forms of violence. In terms of what some of the findings are, and again, it's an emerging area. We're seeing a lot of research starting to come out on reproductive coercion, but some of the stuff that's been found around the intersections with other forms of violence is we found about a 21% concordance rate for people who had experienced reproductive coercion and other forms of domestic and family violence. That was in the context of a service that provided counselling for an unplanned pregnancy, so a very specific kind of context. We also know that some of Heather's work has looked at women who commonly report domestic violence more broadly, and reproductive coercion within that as a form in those abusive and controlling relationships. And there has been some investigation into how domestic violence support services actually respond to reproductive coercion, certainly in other countries. But ours was the first study that had started to look at the Australian context, looking at for people who are then going into domestic violence support services, where they might be trying to do protection orders, they might be trying to have other legal supports. How are those workers in those services understanding what reproductive coercion is? How does that then get used? Is this something that would become part of the evidence that might be presented in protection orders or not? How is the law currently actually being interpreted and being used to support women in those cases? Are there any limitations? And certainly trying to understand the gaps that people may be facing in those areas. So we came in with a multi-pronged set of research questions, really, because we just didn't know much about what was actually happening in this context. And we all have obviously our different viewpoints. So we chose services in Melbourne and Brisbane, and that's because the laws in those two, in Victoria and Queensland, were quite similar in their wording and include, obviously, or can include coercive control or aspects of coercive control. So we were wondering then for the domestic violence support services in those two cities, what are they seeing in terms of reproductive coercion and how's that translating? So we had two specialist community legal services, and we had two services that supported primarily exclusively migrant and refugee populations. And there's just two generalist domestic violence services. So we matched those across the two states and ended up doing, it should be 6 focus groups. No, all good. I didn't pick up on it. We have all reviewed these slides endlessly. 6 focus groups with 38 participants. I'll just move on though, because this shows it a bit more clearly. So we had a combination of lawyers, social workers, and counsellors, which obviously represent the makeup of the staff working in the services, and across the two states there. So in terms of some of the issues that we identified, there was lots of findings that really related to the understanding of reproductive coercion and lots of confusion about that. I think, Heather, you're going to go on to talk a little bit more about that in a moment, so I won't say more. And also we identified a number of different issues with the law, including how it was used in documents, how it was used in terms of disclosures and the evidence pertaining to that, late disclosures, and the impact for the woman over time and her credibility. The other findings that came out that Laura is going to talk a little bit about was around those populations of migrant and refugee women, where there was a significant complexity. And there was some stuff that was around the importance of language and the way that we, for people who maybe don't speak English, how that then has implications for how they talk about, report reproductive coercion and abuse. So at this point, I'm going to hand over to my co-presenter, Heather, who's going to talk us through the findings around the law.
Thanks, Nicola. So yeah, one of the first questions we asked the focus group participants was how they understand reproductive coercion. And we actually received some really interesting feedback in response to that question. The first quote that I've included there shows the sort of breadth of the kinds of behaviours that some of the workers included. So it can include anything that might be from forced sexual violence to stopping someone from using different forms of contraceptive, tampering with contraception, also forcing someone to have abortions if they don't want to have them, and stuff like that. Anything that's controlling someone else's autonomy and their choices around their own reproduction. It's quite common, I found, in domestic violence, but it's always been an aspect of broader control. So I've got a really sore throat today. So there was a lot of comments around those kinds of things. And what was interesting about our workers too was there was a lot of connection between sexual violence and reproductive coercion. And sometimes it wasn't absolutely clear if workers were talking about sexual violence or reproductive coercion. So there was a bit of work to try to tease out those questions, and I think there's more we could do in that space. So they were really connecting those two things very strongly in many of the cases, in many of the comments that they made. They also talked a lot about the limitations of using hidden contraception as a response to reproductive coercion. A lot of literature talks about this as one way that women can gain control over their contraceptive use is through using hidden contraceptions or contraceptive devices or hidden other forms of contraception. But the workers pointed out that there were lots of issues with that being the response. Some women can't leave the house on their own independently to go and get an individual medical appointment by themselves to have that quiet conversation with a doctor. They're not allowed to leave without their partner. The partner's always attending doctor services with them. And even if that's not happening, some women were talking about how they have a lack of privacy, that they might be using My Health Record, but their partners are actually logging into that to check out what's going on. So actually using hidden contraception or having an abortion or doing anything like that without telling their partner is often going to be found out through that, looking at the My Health Record if that's what they're using. There was also the point made that suggesting that women have to use hidden contraception in order to respond to this really limits their choices around contraception. So it's another form of control effectively, or facilitating control. And also some women talked about the greater risk they experienced if their partner did find out. So that if they're in a controlling relationship and they go out and sort their own contraception out, that might really exacerbate the violence that they experience. And might work for a little bit of time, but if it's discovered, they might find that they're punished for exercising control over their bodies. So real concerns about that response. We also asked them, I mean, given the complexity of the definitions, obviously, it seems like it may be difficult at this stage to think about how it would be included in legislation, but nevertheless, we did talk to them about this issue. And I think it's fair to say that most of the workers work most of the time with civil protection orders and family law. So their focus generally wasn't actually on criminalisation. It was on those other areas of law that is often used as a response to family violence. And so whether legislation could usefully talk about reproductive coercion in those contexts. And I think generally there was a strong view from many of the focus group workers that it would be useful in some way to recognise reproduction in current legislation. And although they did say that the notion of using reproductive coercion, that word in itself, they described it variously as a fancy word. They said that that wasn't the kind of language that people that are speaking to them about their experiences, that's not the kind of language women use when they're describing their experiences of this form of abuse. So perhaps not using that language in legislation. There are other options though. We did talk to them about the idea that Victoria and Queensland already recognise coercive control in the definition of family violence in both the Family Law Act and in their local civil protection order legislation. But there was a view held by many of the workers that that's probably not enough to highlight the fact that reproduction is potentially part of that coercive and controlling behaviour. So, for example, they said things like, focus group 4 person, I think the legislation should speak to it rather than people having to have their own interpretation. They also pointed to the value of the law in educating people about wrongs. So someone could read that in the law and be like, oh my God, he did that to me. I didn't know that was reproductive coercion. I think that could be really helpful for clients to actually see their experience reflected in legislative frameworks. And that third quote there, the law can act in an educative way. The law is powerful. And if you say in the law, it's recognised this is domestic violence, they could go to their counsellor and say, this is what happened. I've experienced domestic violence. I want to get a civil protection order, etc. The issue was, though, whether it should be separate separate to the general definitions of domestic and family violence, listed within the definition or provided as an example. And there was lots of discussion about how we could best integrate reproductive coercion or concepts related to it into legislation. A lot of people suggested it could be an example, and there's both the Family Law Act and the Victorian and Queensland definitions of family law and civil protection order legislation include examples of various forms of family violence, so it could be included in that context. So there was some discussion about that as well. Thanks, Nicola. You're on my wavelength. There were also issues reflected by the workers in relation to issues with naming reproductive coercion in court documents. And it's difficult for us to know exactly, I think we need to work more on this, whether they were actually talking in many cases actually about sexual assault and sexual violence. Because as I said, there seemed to be a real enmeshment in their concepts around sexual violence and reproductive coercion for a lot of people. So sometimes they would be starting off talking about reproductive coercion, but then slipping into their experiences of working with women who'd experienced sexual assault and sexual violence. And while there is a lot of overlap between the two concepts, in many cases, they're not always the same thing. So I think we need to think about this a little bit more. But certainly they suggested that if reproductive coercion, like sexual assault, is named in documents, so affidavits in the family court or civil protection order applications, for example, there's a greater likelihood that those kinds of allegations will be contested by perpetrators in comparison, say, for example, to physical assaults or stalking and so on. So that's interesting in itself, that reproductive coercion is in the box with sexual assault type behaviours and is more likely to be contested. And obviously the concern with that, and that was a common point, is that that has all of these ramifications down the road. It extends the legal process if matters are contested. And it also means, obviously, if it's contested, that women are more likely to be cross-examined in relation to their experiences of this really intimate thing that's happened to them. There was also a concern, and I think this is where, is it about sexual assault or is it about reproductive coercion specifically, but that judicial officers are concerned, particularly concerned in applications, for example, for protection orders, if sexual assault or sexual violence or reproductive coercion is mentioned, then that's something that should be reported to the police. Unlike, again, for example, things like assaults and physical assaults and stalking type behaviours that are part of a protection order application, which is interesting as well that they're making this distinction. So they felt that judicial officers are more likely to become a bit more hostile and unsympathetic if reproductive coercion is suggested in materials put before the court. And the point there at the end that magistrates sometimes take issue with sexual assaults that haven't been reported. And finally, in relation to a couple of other things, in relation to evidence related to issues of disclosure, many of the workers pointed out that like sexual assault, reproductive coercion is something that often doesn't come up in the first discussion about domestic and family violence. And so it's not disclosed till they've had several meetings with the client. And often this doesn't happen in domestic and family violence situations where, for example, you're going to get a protection order at the local court. You may only have a bit of time with a lawyer at the court who's on duty that day, so a duty lawyer. So, for example, that first comment, I mean, if it's a duty lawyer, you've got 15 minutes with them. If it doesn't come up, you don't really have that opportunity in that sort of situation. You've got to build up the trust a little bit. So there's also issues too about how to frame the reproductive coercion of evidence because it's often considered an historic event and not relevant. So this is similar to sexual assault. If people are still living together, reproductive coercion and sexual assault can be continuing, but there's an assumption that that kind of thing doesn't continue on separation. So if you've now separated and you fear future domestic violence, the suggestion might be that you shouldn't be fearing sexual assault or reproductive coercion. So how is that relevant to your story of fear of future violence? So that's interesting in itself because, these issues may be able to be exercised from afar, especially if we extend it to things like financial abuse and so on, which might have these limitations to choice and so on. So that was another point that was made there. And just finally, to finish off, and this is related to this notion of not having much time to disclose and therefore maybe disclosing something in a third or subsequent interview between a lawyer and a client, that this might have issues for the credibility of the client. A lot of the workers recognise that a hallmark of trauma is not to be able to tell your story in the same way twice, and certainly also that stories don't come out in a cohesive narrative necessarily, that they're a bit mixed up, and so that if reproductive coercion is something that's really bottled up and not spoken about until subsequent interviews, it may just be disclosed a bit later, and then you've got this risk that the person looks like they're being inconsistent. So this focus group worker said any inconsistency is questioned. Any other versions of those events can be very fertile grounds for cross-examination as to credibility. What I'm talking about is if there's a version, for example, that's been given to the police, then there's another version of the relationship that's in the domestic violence protection order, then one of the things that the defence will do is say, well, you never mentioned this in your protection order applications. So that's, I think, a real concern. If reproductive coercion is one of those really intimate forms of family violence that is only disclosed like sexual assault down the track, is there more danger adding it to the narrative than is an advantage to adding it to the narrative if we're hearing about it later on? And of course, there's this other question too, that women should be able to tell their story of violence. And if reproductive coercion is part of their story of violence, should lawyers be gatekeeping that story? And there are lots of discussion about that, as that can be experienced as a form of trauma in itself. So this quote here, women sometimes feel like they are again not heard, not taken seriously. They're getting totally subordinated in their relationship, but also they believe that the law is subordinating them in the same way. So that real concern that if we block out being able to hear about these allegations of reproductive coercion in the various ways that we're talking about here, that's a form of silencing about women's experience of family violence, and that's another form of trauma that they might experience. So over to you, Laura.
Thanks, Heather. I'm just going to talk a little bit about some of the findings from our study in relation to the unique context for women from migrant and culturally and linguistically and diverse background. So a couple of the services, as Nicola mentioned, that we spoke to were specialist services for migrant women, but even the services that weren't, these issues still came up a lot in the conversations that we had with service providers. And so we focused in the paper that we wrote on this particular aspect, we focused specifically on issues for women from migrant background who were culturally and linguistically diverse, as opposed to migrants from like the UK or somewhere like that. And so what we found overall when we looked at all the data around that was that for those women, there were a whole bunch of structural issues and structural inequalities that were, related to various systems that they encountered, and that those structural inequalities could then be taken advantage of by the perpetrator in order to perpetrate reproductive coercion and abuse specifically. And we've seen some of these issues come out in the literature, the broader literature around domestic and family violence, and there's some really great work out there around women on insecure visas and family violence, but this was the first time it had been looked at in the context of reproductive coercion. So what we found specifically is that service providers talked a lot about seeing clients who were on insecure visas. They were financially insecure and in a situation where they were basically dependent on the partner for, everything really. They weren't able to work because of the conditions of their visa often, or because they weren't allowed to by the partner. They were ineligible for a lot of supports that are in place for women who are born here or who are permanent residents. They couldn't access a lot of those things. And a lot of them had really poor awareness about what their legal rights actually were. So all of those things placed them in a situation where they were much more vulnerable to being manipulated by the perpetrator, to having reproductive coercion and abuse perpetrated against them. So we heard stories about clients who had been told, if you have an abortion, I'm going to cancel your visa. I'm going to send you back to, your home country. Or, if you continue this pregnancy, I'm going to stop giving you any money and you won't be able to buy food for the kids. All those sorts of things were some of the stories that we were hearing from practitioners. And these women who didn't understand their legal rights or didn't have anyone to support them to understand the legal rights, they were really susceptible to that. So the other issue that service providers talked about was that in some communities, there were a lot of patriarchal norms, which of course there are to some extent everywhere, but they were particularly strong in some community groups. And these included things like having an expectation about women's role, that you're going to be a mother, that's the appropriate cultural role for you as a woman, and therefore you don't have a choice about that. It was normalized in some communities that other people would be making decisions about the number of children and the timing of children. So all of those sorts of things created extra pressure on women to take a particular reproductive outcome. We heard a little bit about sort of selective reproductive coercion for the purpose of selecting the sex of a fetus, with wanting male children. That wasn't something that came up a lot, but it did come up a little bit. Service providers talked about some communities having particularly strong beliefs about abortion and the appropriateness of that, or the inappropriateness, I should say, and that, if you had an unplanned pregnancy, that it was just not socially acceptable within those community groups to even consider having a termination, and that not only was a pressure in itself that was internalized by the individual woman, but the perpetrator could then harness that as well by saying, you can't do that. It's against our community. It's against our values, and so forth. And another really strong theme that came up was that many women from migrant backgrounds didn't have a lot of sexual autonomy in their relationships either. So it wasn't just about the reproduction. It was about, not having any choice about when they were having sex, about if they could have sex. It was just expected. That is a service that you provide. It's part of your wifely duties and things of that nature, and that for some of them birth control wasn't even an option, let alone having decision-making capacity about any particular type of birth control. So in that kind of context, it's really clear that reproductive coercion and abuse is going to be a lot easier to perpetrate, because those systems and structures are just, really contributing to that context where it can be perpetrated more easily. And then, of course, on top of that, there was physical, psychological, sexual violence, all of these things happening in the individual relationship as well for many women or many clients that these service providers saw. And then in the diagram there, you can see that just sort of leads down to reproductive coercion and a whole context of where that can happen in a particularly unique context. Thanks, Nicola. And related to that, another paper that Nicola led, we looked at the specific way that language can be used by perpetrators and manipulated by perpetrators to perpetrate reproductive coercion and abuse, or to facilitate it. And so service providers talked a lot about a context for migrant women from culturally and linguistically diverse backgrounds, that a lot of them had a real mistrust of authority figures. You know, some of them had come from very traumatic settings where it was, you know, you couldn't trust police and those sorts of things, and that carried over even when they were here to not wanting to approach those types of authority figures to speak about something like this. There were also a lot of taboos about discussing things to do with sex and reproduction with, you know, male authority figures or male service providers. That was not something that a woman from some backgrounds would feel comfortable doing. So that was the sort of cultural context that situated some of these findings. But then there were a whole heap of barriers that the domestic and family violence and legal service providers talked about in relation to other services. So specifically, they mentioned health practitioners and police as some of the worst offenders of this, but that there was a real reluctance to use interpreters, that there was a perception that the level of communication they were having with women was already good enough. You know, they were able to communicate in a relatively basic way, and that was fine. They could see that there was a problem, they could communicate something about that problem, and so that was fine. So that became very problematic, of course, with such a complex and, you know, nuanced problem like reproductive coercion and abuse, that if people are not even disclosing at a first interview or a first consultation, as Heather mentioned, and certainly that's been what I've found in the research that I've done in health settings, that people don't disclose these things often in the first visit, that if you're just using a very blunt communication instrument to try and talk about this, it's just not going to work. And then, of course, another issue is that even when interpreters are available for some community groups, particularly when they're very small, it's possible that, you know, the victim survivor knows the person who's the interpreter and is concerned about, you know, potentially speaking about this to that interpreter. Where is this information going to go afterwards? Who are they going to speak to? Is it going to get around in the community? You know, stigma and taboo and all of that stuff came into play. And so sometimes even when interpreters were there, they didn't want to speak to them. So this left some women in a situation where the perpetrator was then able to position themselves as the logical go-between, and especially if they spoke English better than the woman did, they were then able to step in and interpret on the woman's behalf, and of course feed the services whatever story they wanted to, or, you know, get them to collude in the reproductive coercion. If it was about, you know, continuing a pregnancy, saying, oh no, she wants to continue it, and all of these sorts of things were happening. And so women were then either subjected to non-consensual procedures, or, you know, forced to continue pregnancy that they would have liked to terminate, or they were just not able to disclose anything that was going on or report because their voice was effectively silenced. So the quote there from one of the focus groups sort of illustrates this, that the service providers, you know, speaking about a client who spoke English fine and didn't actually need an interpreter, but the husband's gone into the GP consultation with her and just said straight off the bat, you know, she doesn't speak English, so you need to talk to me, and silence that channel of communication. So these are the 3 papers that we published from this work, and perhaps we can pop them in the chat or something at the end, so that anyone who wants to look them up can do so. So the first one was more covering the stuff that Heather talked about with, you know, the legal and domestic violence context, and talking about the general views about how that should be recognised in law. sorry, that's the other way around, starting from the bottom. The middle one is the one that I led, talking about some of the issues for the context of migrant and refugee background women. And then the top of the list there, the one about language. So those are our 3 papers for anyone who wants to read them. The next steps for what we're thinking about doing with this lovely multidisciplinary collaboration that we have going is that we're exploring opportunities with some of our partners. And so we've got partners who are, you know, working in the sector and looking at some of their data sets to see if there are opportunities there to do some analysis of that data and work with them on some of their stuff. We're really keen to look at, you know, the gaps in some of the current data and what's missing and what needs to happen, you know, what we need to provide in order to guide best practice in, you know, the domestic family violence sector, in law, in health, across all of those domains. We're really keen to do some prevalence work because that is really lacking, not just in Australia, but worldwide, really. And you know, prevalence work that really speaks to some of those definitional issues that Heather mentioned, that Nicola mentioned, sorry, at the beginning, around, you know, being very clear about what it is that we're measuring and making sure that it's meaningful data. And we're looking at potentially moving towards an ARC linkage grant application maybe this year. So we'll see how we go. Great, thank you. Now, Heather and Nicola, did you want to add anything before are we going to have some questions or, yep.
Nicola and Heather, would you like to add anything before we open the floor for questions?
I don't think so. I might stop sharing, but I'll put in, I think chat's open, so I might see if I can put in chat.
That's great, thanks. And we have those references as well, so we'll also put them on the website with the recording of today's seminar so that people can follow up. Well, thank you all. That was really fascinating. Lots of really interesting issues that you've unearthed in this research. So let's open the floor for questions. Feel free to put up your hand or write your question in the chat. And if you put up your hand, I can then go to you to ask you your question. So. Thanks, Nicola, for putting those in the chat. So can I lead off then with, I've got a few questions, but I'll just start with one. Heather, I'm interested, are there any areas of law, so putting aside the sort of the family law context and then the sort of the civil jurisdiction specifically around intervention orders, are there any other areas of law that like touch or almost touch the issues that come up in reproductive coercion, or is it kind of really that there's no law that has tackled the issues in this area?
Oh, well, I mean, stealthing is the obvious one. I don't know if you're trying to point me to that, but there is discussion at the moment of the introduction of a stealthing law in Victoria that's come out of the Victorian Law Reform Commission's recent report. And while we think of stealthing as the expectation that a condom will be used in sex and it's removed at some point without the consent of the other party, the definition that's used in the Victorian Law Reform Commission suggested framing of stealthing would include other devices. So it wouldn't just be limited to condoms, so it could have quite wide ramifications. So there are stealthing laws in other places. There's one in the ACT. So I think that obviously has a really significant connection to reproductive coercion. And there are real questions too around rape and sexual assault law. And if we think of consent as free agreement, many of these contexts of reproductive coercion, you know, in theory, could reach the threshold for rape and sexual assault, although that just really wasn't a real concern of the people we were speaking to. I mean, others in the room might have more knowledge of other areas of law that they might be familiar with, which might have implications here, but criminal law was the obvious one for me, and what I thought they might talk more about but that really wasn't a focus. And I think that's because, you know, women who are trying to get closure for domestic and family violence, you know, often seeing domestic violence workers in relation to civil protection orders and family law matters, and dealing with the police around criminal justice matters more so. So there's less connection between those systems. But yeah, certainly stealthing is the obvious one there.
And can I just prompt you?
Sorry. Yeah.
What about immigration law, not as one that is actually helpful, but as one that needs?
Yeah, so one of the problems with immigration law is that the legislation around, so in Australia, that's why we picked Queensland and Victoria, was because, as we've mentioned, those key pieces of legislation, including criminal law, really are very similar in terms of the domestic violence protection order legislation includes coercive control, as does the family law. But immigration law, so spousal visas, and if someone's on a temporary visa and they separate because of family violence, and then they then want to get access to the domestic violence exception and then get a permanent residency opportunity, proving domestic and family violence in that context is different. The definition is different to the Family Law Act, despite being Commonwealth legislation, doesn't include coercive control. So it would be much more difficult to think about reproductive coercion as part of coercive control under immigration legislation, for example. Yeah, good point, Nicola. Yeah. I mean, you know, I felt like a lot of the issues we were facing, and Laura and Nicola might want to talk more about this, but the kinds of behaviours that were being reported in the health context were incredibly shocking, and certainly would have implications for the health practitioners in terms of the behaviours that were being, I don't know if you want to talk more about that, but we heard about workers trying to shuffle women off to the bathroom so that they could have a private conversation with the client about their options, for example. So this is a really difficult area, I think.
Thank you, Heather, and thanks for the answer. Catherine Gilbert, thank you.
Hi, my name is Catherine Gilbert. I'm from the Nussel Institute for Global Health at Melbourne Uni. I'm not sure if my memory is serving me correctly, but I think I've read about reproductive control, coercion, papers from other contexts globally where they haven't just looked at behaviour by partners, but also other family members, I think mothers-in-laws. And I just wondered if you consider that in your framing and what reflections you have on that.
That was certainly one of the findings that came out. You talk about mother-in-laws literally being the one who's holding down the woman as the son is having sex with her to cause pregnancy. Laura, did you want to say a bit more?
Yeah, I just wanted to agree and say, yeah, absolutely. And in that diagram, that's why we've got the family violence, you know, acknowledging that it's not always the intimate partner. And we definitely did hear stories about those sorts of things, particularly in relation to culturally and linguistically diverse women, but not always. Of course, it doesn't just happen to them. Yeah, thank you, Nicola.
Yeah, and I think the other kind of perpetrators we heard a lot about, and it depends again, religious leaders would be colluding or helping, usually the partner collude. So we had religious leaders. There's other emerging evidence, not from our studies, we didn't hear much about it, but certainly carers and disability, and you know, there's it's an interesting area of people considering who and how, what behaviours are being used by different perpetrators in different contexts. So we did hear bits about it, and certainly our papers do consider some of that, but I think predominantly you see it in the intimate partner space, and they are predominantly the perpetrators. But yeah, certainly is more broad than that.
I mean, there's also the selection of support for families. So the selection of particular doctors who hold similar values to the person that runs the household. So there's a lot of that seems to go on too, or that's what the workers told us about anyway. So there's a whole of community kind of pressure on women to. This is especially Laura's point about, you know, normalising particular behaviours or certain cultural expectations or social expectations in particular groups. And certainly we saw a lot about that. Yeah.
Thank you. So we just have a comment in the chat from Illy So Illy, I'll read it out unless you jump in and say that you'd like to.
I can do that.
Yeah, great. Thank you.
Okay. Might be a little off target, but I live in the US, is starting to remove the last safeguards for Roe v. Wade, which is, can you still hear me? You're kind of frozen.
Yes, we can. You're a little bit crackly, but if you keep going, thank you.
Okay, cool. Yeah, so the right to abortion in Roe v. Wade was based on a right to privacy, as like a right of autonomy that way, rather than a right to equality, which is likely a big part of why it's so easily overruled now. And obviously you're not studying the US Constitution a ton, but I was just wondering what reproductive rights are based on in Australia and how that strong legal foundation can be built. I know, like, because it's obviously contested in Australia as well as the US. So how do you build that legal foundation that makes these laws unoverturnable or less overturnable?
Thanks, Illy.
I mean, that's a really good question, and I don't know that we know the answer to that. You know, when we were working towards reform of abortion laws in Queensland, there was a real evasion of human rights, for example, and there was sort of this notion around individual autonomy. So that was part of the analysis. But I think now there is a view that since the human rights legislation has been brought in Victoria and Queensland, for example, abortion is based to some extent in human rights. But I'm not sure. I don't know that we've really deeply had that discussion to talk about that. We probably should, because I understand that I can understand that there's this potential threat, ever-present threat, I guess, to the winding back of abortion laws. That would be an interesting thing to explore further.
And can I just say, for those who are in the US, our hearts are bleeding over here, and we're all watching with great interest and concern. So yeah, but I think Heather's right. I mean, we do live in this state of, and we've seen in certain states at certain times there has been a winding back of. Luckily, recently it's been an expansion of laws into safe access zones, and tends to be an expansion, but not specifically. Didn't South Australia wind back a little bit not long ago? Or anyway, so yeah, we are at risk of that here in Australia. And I think our problem here is we have state-based laws, which is similar. We don't have abortion's not nationally anywhere, is it? Is it a national?
Well, in the TGA approvals around abortion medication, but state-based basically. Yeah, no, that's interesting.
Thank you. Is there any other comments or questions for our panelists? I'd like to ask who is, sorry, Heather, I cut you off. I was
going to say, I mean, we'd be happy for feedback on where you think we should take this to, because it's very much a debate we're having between each other at the moment about sort of next steps and exactly which directions we want to go. So, feel free.
Thank you. So maybe people feel free to chip in on that point. I wanted to raise with Laura about healthcare workers and GPs in particular, and it was picked up a little bit, but just in terms of how much current, I suppose, medical school training, and then how much ongoing professional training raises these issues and equips GPs in particular to deal with women who are facing these kinds of problems.
None. They get none. No, okay, so there's various pockets of training, including my colleagues in Department of General Practice, that they are rolling out fabulous training that looks at responding to family violence and domestic violence, but there's still not really any content about reproductive coercion specifically. And, the training up to recently for healthcare providers has been almost non-existent. Like in terms of when they do their original medical training, there's tiny, tiny amounts of family violence training in those courses. And for, you know, some professions like psychiatry and psychology, there's very little as well, if any. And of course, that is a big problem. So, you know, people can choose to upskill themselves later by enrolling in various courses, but that's sort of up to the individual. So, I mean, one of my students did interviews with primary care providers about reproductive coercion and some of the barriers around responding. And look, most of them said it's not even on their radar. Like, it's just not something that they particularly look for or ask about. And if they do ask about it, they don't really know what they can do and who they can refer to. So yeah, there's a lot of problems there around response, and it is really critical that healthcare providers are trained in how to look for it, how to ask about it sensitively, to know what to do if somebody does disclose. I mean, I've done a lot of work with the Women's Hospital, and they are better because they have co-located services. They've got, you know, pregnancy counselling services that are embedded in the hospital, and they have a really good understanding and a really strong commitment to family violence prevention. And so services like that are excellent, but then there are just so many GPs and so many individual services or places that somebody could access if they were experiencing reproductive coercion. And ideally, any service that they approach would be able to, you know, work out that there's something going on and respond and refer if necessary, and help them out. So yeah, it's definitely a big problem in health, and it's something that I've spent a lot of time trying to raise awareness about, and will continue to do so.
There's a question from Isaac in the chat too, it's a change of topic though. So, but it's talking about mental illness experience. And I've got to say, as a clinical psychologist myself, this is completely something I've been pondering a lot lately. One of the things that there's, you know, and again, we have small evidence bases at the moment, but it's certainly something I'm interested in, is around the associations between reproductive coercion and mental health. We know that reproductive coercion can impact on health, as can any and all forms of violence against women. But which, you know, the reciprocal relationships between these constructs, and the fact that people have mental health issues and then, you know, maybe are more at risk potentially. I mean, there's no evidence really looking at how the intersections, particularly as you're saying, with quite severe forms of reproductive coercion. But I agree, we do see it a fair, you know, we do hear anecdotally. Trying to unpack this in a research design is quite tricky, and I think it's certainly, yeah, as I said, my head is here, but I don't quite know how we're going to go about doing that. But you're certainly preaching to the converted in me. I can't speak for Heather. This is where we have our arguments. Psychological health is, of course, the best way to go, not the law. And then yeah.
Well, we know that clinical mental health services don't have a good track record in relation to sexual assault. So chances are this is not any better.
Yeah, look, and we had two examples in the paper on language. It was counsellors and psychologists who were the ones then where they were really surprised that the violence and the reproductive coercion wasn't coming up in reports. And then it came out that the husband had attended every session. And of course, we even at a really fundamental level need to look at processes across the board and education and training for even people who are counsellors and psychologists and so on, where we do have ethical codes that should prohibit or address some of these issues and still don't. So I think there's a lot of work just generally in education, as Laura is saying, not just across health, but health more broadly, I guess, than just medical. Yeah, rural.
Thanks, Nicola. And then Nicola in the chat has said, so how women who live in rural parts of Australia deal with their experiences of reproductive coercion and abuse needs exploring too. We know they have more difficulties accessing abortion, so I'm sure there's problems with disclosures and support systems in place for RCA victim survivors in those regions too.
Absolutely. Thanks for that, Nicola.
On the psychology stuff, we had a lot of people talking about the real angst that women experience after having experienced reproductive coercion, which has resulted in children being born effectively out of, you know, unwanted sex or, you know, situations they weren't expecting to get pregnant from. And so that there's this real trauma for women to even describe that as abuse, because now they have this child, and to try to separate the abuse from the beautiful child that they have that they want to care for. So there's real complications for women experiencing that as well. And a lot of the work has talked about that also. So the sort of psychology aspect, the counselling aspect is really important there, I think.
Yeah, and that just brings up for me the other intersection that we haven't yet explored, but I certainly really am interested in, is child safety. It came up a little bit peripherally in some of the things we were talking to and about, but, you know, people who have then got multiple children and who might be in contact with child safety services, and then how reproductive coercion is understood and dealt with in those contexts. Yeah, as another area that needs investigation.
Thank you. Are there any final questions from the room? Okay, and then any final comments from Heather, Nicola, or Laura to finish this really great session?
Thanks for the opportunity, and I guess we would all be really pleased to hear from anyone. It's been great to hear the ideas in the chat today and the conversation. So yeah, feel free to get in touch, and really thanks for letting us share what we've been doing.
Yeah.
Well, thank you. Thanks for a fantastic session, and congratulations on this really important work that you're doing. And so we'll be really interested to see where you go next with the project. So it sounds like there's different paths, and it's about deciding where to take it. So thank you very much. Please join me in thanking Heather, Nicola, and Laura today. Thank you.
Thank you.
Thanks, everyone. Thanks for having us.